feels like it's a case beyond his jurisdiction, magistrate court will refer it to the state high court, not the defendant.
No, I beg to explain further. It depends on the case. There are some cases that the judge or the magistrate will say whether they have jurisdiction or not. But there are some cases, I have been through them. I have 3 or 4 experience. They will ask you, where do you want to be tried? In high court or here?
That is not correct.
That is correct.
Give example of the case. Give example of the case.
I am an example.
Okay.
I am an example of.
Mention the case, please.
4 times I've been tried at the magistrate, and thank God 4 of them was dismissed. So I'm speaking from experience.
So what case were you asked? So in what case were you asked whether you want to be tried in the magistrate in the state high court and you chose magistrate? Kumastic Kuma.
It was
Kumastic.
Hold on. I can. It's in a versus Commissioner of Police of Lagos.
Who versus Commissioner?
4 times. Me versus Commissioner of Police of Lagos.
So you were asked in Lagos here where you want to be?
Yes.
And you chose magistrate court?
Yeah, in front of you. Yes, because if you choose high court, they will remind you in custody. Then the high court process is longer. You better take that magistrate.
Why would they remind you in custody when you were already on bail? It depends on your condition. Before you went to the court, like were you?
Exactly. But the magistrate can say, well, since you don't want to be here, but your lawyer can come up and say, okay, after you give him bail, you will now go to the high court. But lawyers will advise you, take your plea here and ask to be tried here, because high court is longer.
I don't
high
understand.
Court is more.
Let's say, for example, now, the nurse has been under the police administrative bail for a very long time, right?
Yes.
So let's say she presents herself before the court. We don't forget she came from home. She came from home to court. So let's say after pleading guilty or pleading not guilty, are you saying that the court will advise them to take away her freedom, which she has already gotten all this while? So her freedom will be taken away.
The court has the jurisdiction to decide whether to continue with the administrative bail or to institute. But let me tell you, if you say you don't want to be tried there, the magistrate will refer you to the high court. And that means you have
that's not correct.
to sleep that is correct. That is correct. Let lawyers come up. Let lawyers come up. I don't want Temu lawyer. Let lawyers come up.
How can you stand in front of a magistrate and be telling her where you're not the one who took yourself to court. Prosecutor took you to court. So you want to be telling the magistrate that you are commanding her that I don't want to be tried here, I want to be tried in another court.
No, you have the right. No, you have the right. And I've been advised, I'm telling you, 3 to 4 times, that take the plea here. Because if you say you want to go to high court, it's a new body.
How do you get to high court? Who takes you to high court? Wait, who takes the person to court?
Because you have chosen not to be tried.
I want to ask you a question. Who takes you to court in the first place in a criminal case?
In the criminal case, is the police prosecutors.
So when you were taken
to court,
did they ask you which court you want to be taken to?
No, when you are taken to court, they take you to magistrate. And when you are the magistrate, the prosecutor comes in.
Are you technically saying that you must always be taken to magistrate court in every criminal case?
Most of the time, they will take you to magistrate first.
But it depends on
high court doesn't have
not correct. It depends on the kind of crime. If you commit a murder case, case, nobody will take you to magistrate court because they don't have jurisdiction over a murder case.
They will take you first. They will take you first for further reminding or they know you are going to high court.
You were already under remand. You let's say anybody who is charged or anybody who is like pegged with a murder offense. Okay, let's say for example in the case of Bamishi, the BRT driver who's alleged to have killed Bamishi has been remanded since 3 years ago. Okay, and after that the case was filed straight to the state high court, never in the magistrate court. So why are you bringing magistrate court in a murder case? Magistrate can't even preside over a murder case.
Because the prosecutor, yes, exactly, because the prosecutor knows the case and they don't want to waste their time at the
and that's what I'm saying now. It depends on the crime.
If it is in the afternoon,
it depends on the crime.
And they don't hold on, wait now. If it's in the afternoon before 4 o'clock or after 12 o'clock.
Sakuma.
And the hold on, and the prosecutor, let me finish, please. And the prosecutor want to remind you longer than the 48 hours that they have. They will take you to a magistrate.
Police up or magistrate.
Police prosecutor will take you in front of the magistrate to have your district extended.
Let me quickly read something. Let me read something for you. All of this long story is not necessary, to be honest. No magistrate courts in Nigeria. Magistrate courts in Nigeria do not try murder cases, while they handle many criminal cases, including felony cases.
Jack, what did you say?
Like manslaughter.
What did you say, Jack? Do not try.
No, magistrate court do not try murder cases. While
you say trial is different from detention. Trial is different from detention.
Once it is a murder case, they have no jurisdiction to do anything about it.
They have jurisdiction to either detain you further.
Any lawyer who goes to or any police prosecutor who goes to a magistrate court to file a murder case is already it's a failure already. So the magistrate is never going to try. It's not even going to do it.
Jack, you are saying, listen to what you are saying. Trial is different from detention. Trial is different. You are not taken to a magistrate to be tried. You are taken to a magistrate to be further detained. Please listen to what you are saying.
First of all, Sakuma. First of all, if you commit a murder, you can never you're not going to be taken on bail. If it is a murder case you are charged for, you are going to be in prison. They're going to bring you over from prison to high court for your case. You are never going to go to your house. Nobody's going to bail you. If it is a murder case,
I pray you listen to yourself. That's all I can say. I'm not arguing any further.
You are not
listening. Trial is different from
trying to read something
arrangement.
Paparano is right.
Trial is different from arrangement. Trial is different from arrangement to be detained or to be further detained.
What do you need to take? Why do you need to take suspects who are charged for murder to magistrate first when you can take them to high court straight? To do what? Can you answer that?
We are talking generally now. Hold on. We are talking generally now. You are insisting on murder case. The murder case that have been finalized.
That is what I'm telling you. That magistrate can handle when it comes to felony, when it comes to like manslaughter, But murder is a serious offense that is tried only in high court.
You see, there's a difference in trying and there is a difference in arraignment. You can use either of the courts to do arraignment. Arraignment is, do I release this person or do I detain this person? After 24 to 48 hours, police don't have that right anymore. They have to either go to a magistrate or a high court. Most of the time, they go to magistrate. And after the magistrate, they
Takuma, what I'm saying,
transferred to
I'm saying to you is this. This is what I know for certain. I'm telling you that if it is serious offense like murder, they can only be arraigned in high court. Underline it, high court. That is where you're going to be arraigned. You can't be arraigned at magistrate court for murder. That's what I'm saying. It's simple. Your case was not a murder. If it was a murder, you won't have that option that you're talking about. If it was murder, you're going to be in prison all through the case. Throughout the whole case. They'll be bringing you from maximum prison every time your case.
Hold on.
Till the case
is he not charged for murder?
Because the nurse is not charged for murder, she's charged for negligence. That's a small offense.
Thank you.
And why she's been arraigned, they are being arraigned at the magistrate. Because our offense it does not have weight. It's not weighty. It's not serious.
Murder, Jack, end by saying, murder trial, quote, murder trial are tried in high court.
Do you know when they say try? You know when they say try? Try does not mean trial. Look, you're getting something wrong. When they say murder cases, magistrates do not try. They cannot try murder cases. What they are saying, they are not talking about trial. They mean that they have no jurisdiction. Magistrate has no jurisdiction over a murder to hear a murder case. That's what it means. It means that murder cases can only be heard. The suspect can only be arraigned in high courts. That's what that trial means. It doesn't mean that trial. No.
All right, let me read this information. Maybe this will be helpful. we can add this to our knowledge. Because I asked, why do most criminal cases start in magistrate court, to see what can be relevant? Most criminal cases initially appear in magistrate court because this court have lower jurisdiction and handle less serious offenses compared to the high court, which deals with more complex, that is the high court, which deals with more complex severe crimes. Magistrate courts are often the first stop for all criminal charges, serving as a preliminary hearing and deciding on matters like bail. Now, magistrate courts have jurisdiction over less serious crimes, including minor traffic violation. There is noise on your side, Sakuma. Magistrate courts have jurisdiction over less serious crime, including minor traffic violation, public order offenses, and some assault cases, according to Nigerian and some law. They can also hear more serious cases that may be referred to the High Court for trial. Now, preliminary hearing. Magistrate court conduct initial hearings to determine bail, assess the seriousness of the offense, and potentially decide whether to send the case to a higher court like the High Court. Starting with the magistrate, there's nothing you said. Now, please wait. Let's read everything now. Don't be rushed. Don't cut this, please. Let me take it back again. Magistrate court conduct initial hearing to determine bail, assess the seriousness of the offense, and potentially decide. That is magistrate court deciding. Don't forget, I'm coming to you saying that the individual will decide where she wants to be taken to. I say no. It is a court that decides that. So magistrate court conduct initial hearings to determine bail, assess the seriousness of the offense and potentially decide whether to send the case to a higher court like the High Court. Starting with magistrate court can help streamline the legal process by initially addressing less serious matters and allowing for efficient case management. The seriousness of the offense is a key factor in determining which court will hear the case. If a case is deemed too serious for the magistrate court, it will be transferred to the High Court for trial. Trials in the High Court, especially on indictment or information, are often more elaborate and involve procedure like proof of evidence, arraignment, and place. So anyway, this is the basic. Now you can address it, Akuma. Well, for me, what I understand here is that sometimes most prosecutors take cases to the magistrate court, so the magistrate court will hear the person's position, like, hey, first, do you accept these charges that is brought against you? Do you accept, did you do this or not? So when the magistrate assesses the case, he will assess it, and don't forget, let's differentiate between police bail and court bail. When the police is investigating you, if police don't have sufficient evidence that you have committed a particular crime, okay, and they cannot detain you more than 48 hours, and they need more time to investigate you, police can temporarily give you a bail, okay? They can be investigating, you can go in and be signing. Maybe every week you go and be signing while they are still investigating. But let's say police now have sufficient ground that you committed a crime, and they have now charged you before the magistrate court. So now don't forget, you came from your home. Now you are no longer under the police. Police has done the investigation, has brought you, have deposited you in front of the court. Now, it is now up to the court to think like, okay, this person has been brought to us, like unfertile or whatever, like remove all the handcuff, everything. This person is now under our jurisdiction, no longer under police jurisdiction. So now, how are we sure? Now, they will now reassess. They don't care about whatever bail before. They will now reassess that, okay, how are we sure that now that this person came, and this person, we have read the offense of this person to this person. This person now knows the offense he has committed. How are we sure that this person will come back for trial? So then they will now decide whether they want to remand you, like go and keep it. Now it is the court ordering for you to be kept there pending trial. So they will now decide whether they want to remand you or they want to have you on bail. But I'm wondering, like, maybe this is where you have to come, Mr. Akuma. Let's say in the case whereby I was on police administrative bail, I was taken before the magistrate, and I'm right there in front of the magistrate, right? And my offense were read to me. Let's say the magistrate wants me remanded, okay? And she pronounced for me to be remanded. Are we saying that my lawyer will immediately enter unprepared, will automatically becomes a shorty, and I will not be remanded, or I will first be remanded and then they will now bail me? Like, since you were in the process, in your own case, like me, I've never been arrested, I've never had police case. So the 4 times that you went through this process, Akuma, like, how did it look like?
Experience.
Yeah, tell us of experience, bro.
My experience, the prosecutor, my experience, the police investigate, they will hand you
your network.
Their prosecutor. Usually, it doesn't matter, from sergeant up. When they hand you to the prosecutor, network is bad. Is it still bad? Is my network still bad?
I can hear you. Go.
Let me change my network. Maybe.
All right. Change to me. I think I'm in MTN. MTN2 is very low. I'm gonna try it.
Is it better now?
just speak on. We can. I think it's better than speak on.
Okay, when they place you to they will prepare the charges. Your lawyer will come to you and advise you that the magistrate will ask you, do you want to be tried there or you want to be taken to high court? It's the magistrate, because the high court will be tedious. Since your offense are lesser charges, lesser offense. What I am saying is that administratively, even a murder case, will still and can still pass through magistrate.
You're not answering the question.
Is going to try that case.
Please wait, don't say me.
Normally,
please wait. Oh my God, there's network issue. Please wait. You're not getting my question. My question is this: somebody who was on bail before, he came to the court by himself with his lawyer. He didn't come from prison. There are some people that police refuse to bail. They come on handcuff and they remove their handcuff when they're in the court. I'm not talking about the situation. I'm talking about somebody who came from home straight to the hearing, like how the nurse came today for hearing. Okay, so right there in front of the magistrate, let's say the magistrate decides that she should be remanded. How is it the lawyer that we immediately stand for him or brings a shorty? And why is it that this particular nurse went today and she was not remanded? That's what I was asking. And your own case, as somebody who has went through 4 of those cases, like you were tried 4 times.
Because
so how did it look like?
Can you hear me?
Mm-hmm.
Can you hear me? Better. You see,
can you go back to the next?
Charges was.
Can you go back to the previous network? This one is not good. Check the previous network.
Let me try.
Anybody here who has gone to jail before, please come up. We need your experience. If you have ever been arrested, if you have gone to jail and then you came back, please come up. This is your time. Please send request very quick. This is your time.
Need to be shared.
Yeah, go on. Tell us from your experience, Akuma.
Being charged is when you get convicted. Even some people get still. What I am saying is,
Akuma, forget about what you are saying. I asked a question. That moment you are in front of the magistrate for the first time for hearing, she can decide. She can decide whether she wants you to be remanded or she wants you to be on bail, court bail. Okay, so let's say she wants you to be remanded right there, and she's gonna list out the conditions of your bail. Right? Would the lawyer immediately go into negotiation? How would they provide shorty immediately, or the lawyer will stand for you? That's what I'm asking. I don't think you have gone through this. Maybe you're not the right person to ask a question. It's okay. Me, I've never been arrested. Maybe when they arrest me, I'll go understand. I'll understand what's up. Yes, so any other question before we continue? Any other question before we continue? Or does anybody still want to answer to that? Any answer to this effect? Any question, any answer?
Did you remember some few weeks ago I asked the same question that those guys were not even supposed to be granted. I guess somebody said they granted them administrative bail, and it's the capital offense. You remember we discussed it here.
No. Peter, please. I need you to understand something. This is for you, okay? When they say capital offense, you need to understand. You need to understand. Can you hear me? Can you hear me?
Yes, please.
Yes. I think you're having issue with an offense of killing. Offense of killing is basically in 3 categories. Killing is not always bad. Okay, depending on what you kill for. Now, some people can plan the killing of somebody, premeditated, right? When that person dies, they have committed murder. They plan the killing. There's intention to kill. Now, in some cases, you don't plan to kill somebody. You came to treat the person, inject the person. The person died out of mistake. It's negligent. It has a different punishment from that. The third kind of killing, somebody came to your house with gun to steal, has killed your dog, is shooting sporadically, and you have your own gun, you shot the person dead. Alright? Because you kill the person does not mean it's capital offense. It is the police who understand the law that will look into the crime. When they look into the crime, then they will declare you a suspect of either murder, suspect of negligence, or a suspect of manslaughter. If in case maybe you killed the person, or you have your reason why you killed the person, which you can argue to be self-defense, but police may say, okay, it's manslaughter. Somebody died in your action. In your action, maybe whatever you were doing, when you get to court, you will defend yourself. But you don't slaughter somebody in your action. So now, when you are in a murder, when you are a suspect of murder, it is only the judge in the high court that can grant you bail, not even the police. And it's in the discretion of that judge to grant you bail in Nigeria. But when you are for negligence, a more minor offense, though it's killing, negligence is not capital punishment. It's not death by hanging. These are minor offenses that can lead somebody nothing less than 5 years imprisonment. So it's seen as a minor offense. So police can grant bail in such circumstances. So you are thinking that the nurse committed murder. No. Police did not suspect him of murder. Police suspect her of negligence. When your negligence kills somebody, it is different from murder. Murder means you mean to kill that person. There was a plan or there was intention to kill that person. So I don't know that you can get the difference. It's a 2 different things you're talking about.
Papa, it seems you don't get it. In this case, from the very onset, I believe most of us are just talking for making an excuse for some things. The police, when they did their report, they highlighted 3 people, and they tagged them as suspects.
Suspect of what? Suspect of what offense?
To what happened to?
No. Don't use the word what happened to. You have to talk about the offense. There are so many offenses about what happened to Mohbad. Somebody picked the phone and called somebody. The person did not murder, but that's an offense because you take your phone and call the nurse. That's a bad practice. You are being punished for that. That doesn't mean you are being punished for killing Mohbad. You didn't kill Mohbad, but you called the killer.